In a mostly freedom-positive ruling, U.S. District Court Judge John Sinatra Jr. granted to plaintiffs injunctive relief against a blatant New York State attack on the right to keep and bear arms. I'll give you the mostly good news in a moment. Hi everyone, I'm Gardner Goldsmith for MRCTV. What was in question? In question, the July 2022 passed New York statute pushed by Governor Kathy Hochul that tried to slide new gun bans through terminological holes offered by the U.S. Supreme Court in its New York Rifle and Pistol Association v. Bruen decision of June of 2022. Specifically, the state tried to use a carve-out that the Bruen decision offered for so-called sensitive areas, claiming, you got it, the state can designate public places as sensitive, prohibited zones for people who want to exercise their God-given right to carry a concealed firearm. As Michael Katz reports for Newsmax, the ruling in the case called Christian v. James, this new ruling covers two types of places: real government-funded public properties and the type that is getting the most attention in numerous reports, private property that is open to people to enter for activities such as commerce. The kind of property that many politicians errantly claim is public, but is really private. Quote, a federal judge Thursday ruled unconstitutional a 2022 New York law that prohibits licensed gun owners from carrying a concealed firearm on private property open to the public unless the property owner expressly allows it, end quote. And Katz offers more of the background information from 2022. Quote, it is yet another setback for the Democrat-controlled New York State Assembly, which has continually been thwarted in attempts to pass gun control legislation that passes constitutional muster. In a 6-3 ruling in June of 2022, the U.S. Supreme Court struck down a New York handgun licensing law that required residents who want to carry a handgun in public to show a special need to defend themselves. Democrat Governor Kathy Hochul called the state assembly into a special session following the Supreme Court's decision to strengthen existing gun laws, end quote. In other words, Hochul called the state assembly to figure out new ways to attack the inherent right to self-defense. They passed a bill that forbade residents from carrying firearms on government, i.e., tax-connected property, and on private property that's open to the public unless the private property owner posts his or her explicit consent to welcome firearms. That's what the government said. That's the way it's got to be. Well, Judge Sinatra struck down the statute. It's a mostly pro-freedom ruling that sees Sinatra utilize the second tier of what, since that 2022 Bruen Supreme Court decision, has become known as the two-tier Bruen standard. Katz focuses on this portion of Sinatra's 43-page ruling. Quote, regulation in this area is permissible only if the government demonstrates that the new enactment is consistent with the nation's historical tradition of sufficiently analogous regulations, Sinatra wrote. New York fails that test here. Indeed, property owners have the right to exclude, but the state may not unilaterally exercise that right and thereby interfere with the long-established Second Amendment rights of law-abiding citizens who seek to carry for self-defense on private property open to the public. End quote. Thus, Sinatra mixes the good with the bad, producing a result that, overall, stops the Hochulistas from gun grabbing on public property and from dictating to property owners and visitors how they can peacefully arrange their interactions, armed or unarmed. But the problem area is the second tier, or historical analog carve-out that the Supreme Court created in its 2022 Bruen decision. In Bruen, the Supreme Court majority essentially said that future gun grab statutes heard before any level of justice in the U.S. should be scrutinized first on whether the statute in question conforms to the actual wording of the Second Amendment. Well, that's pretty clear because the Second Amendment is clear. It explicitly says the right to keep and bear arms shall not be infringed. And it's right there, which means ever by any level of government. Unfortunately, unethically, and illogically, the Bruen Supreme Court then added the second tier of judicial analysis that it wants other judges to use. That being a look at whether the particular contemporary gun grab statute can be said to have an historical analog to any moment in U.S. history when some other old political apparatus took away people's guns. Which means that that old political apparatus infringed on the right to keep and bear arms, which places the second tier of analysis in opposition to the first tier of analysis in the actual wording of the Second Amendment. In this case, Sinatra concluded that there was no historical analog. So the result of his ruling is the same as it would be if he correctly and solely focused on the actual first tier, i.e., the actual wording of the Second Amendment. But what if this judge had found some instance, say in the 1860s, when some oppressive political subcomponent of the U.S. did steal guns? Would any honest judge claim that such an infringement on the right to keep and bear arms is not an infringement explicitly prohibited by the Second Amendment? This is a mixed bag. It's a mixed bag process, in fact, that actually sees a positive result here, covering both public property, which is always supposed to be open to armed people, and private property, which the owners are supposed to open and close to anyone as they see fit. As the Firearms Policy Coalition, which was involved with the case, puts it, quote, just yesterday, New York Governor Kathy Hochul said that after the Supreme Court's Bruen decision, the state doubled down on its anti-rights agenda. In a statement yesterday, she said that the state came up with legislation and we have a prohibition on concealed carry weapons in sensitive places. I personally think every place is sensitive. However, today's decision again shows that Governor Hochul couldn't be more wrong. Regulation in this area is permissible only if the government demonstrates that the new enactment is consistent with the nation's historical tradition of sufficiently analogous regulations. New York fails that test here, the court said in its opinion today. Indeed, property owners have the right to exclude, but the state may not unilaterally exercise that right and thereby interfere with the long-established Second Amendment rights of law-abiding citizens who seek to carry for self-defense on private property open to the public, end quote. Private property owners always retain the right to exclude armed people, and they're supposed to be able to exercise the right to exclude anyone. It is, of course, after all, private property. But the founders were clear, and Kathy Hochul and her cronies can't weasel their way around the fact that the founders explicitly forbade all levels of government from blocking us in the exercise of our rights in public spaces, tax-supported spaces. While Hochul enjoys armed protection paid for by New York taxpayers, she never seems to stop thirsting for more gun grabs. As a result, she shows herself to be a predator. And every time she pushes for more government activity on every level, she should be called out for the fact that she is the one engaging in aggression and threats. Judge Sinatra has actually done so here. And despite the two-tier Bruen standard that muddles understanding of a very clear human right as supposedly protected by the Constitution, the judge came out on the right side, opposing the governor and her gang. Let's hope more judges will do the same for future legislation like this. Thanks for watching, everybody. Please like and subscribe. Find us on Rumble where they don't censor us. Please follow us there. Share the videos far and wide. You can find us on YouTube as well where they are censorious. And visit us at MRCTV.org. That's MRCTV.org to find out what the whole team is doing. And of course, while you're there, check out the store and please consider donating to the Media Research Center. That would be really helpful. You can always find us inside Facebook. You can also find us on TikTok and Instagram and on X. And if you want to follow me on Gab, I'm at Gardner Goldsmith on Gab, and on X, I'm at Gard Goldsmith. Thanks for watching, everybody. Please share the videos. For MRC TV, I'm Gardner Goldsmith.